Is Cam on?
Sally.
Hey, no Cam, so I have a chance, we'll have that.
I'm sitting behind her. Can you hear me? Oh, I don't know. I can't hear you. Say that again.
Looks like everybody's tired from yesterday's event.
Food coma.
Food coma. Man, I was just planning on having you guys in the background and working, but I guess I'll have to participate.
We have a very serious competition going on here, Dallas. All right. We've got Australia, Ivan, and Dallas. And then anyone else?
Tonight is the phone.
Okay, coming in. Okay, good.
Yeah, let me hop on Zoom also, starting to get Dallas against.
All right, Dallas, so what we'll do, you'll message directly to Emily your answers.
Okay.
Right, hopefully everybody's got their thinking caps on today. No. Got some tricky ones in here.
Always.
Gotta keep you on your toes.
Yeah.
I know about that. Emily, let me know when you're on and then we'll figure it out.
I think I got almost everyone wrong last time I did it when I was on Zoom.
What was that?
I think I got them all wrong when I was on Zoom.
You learned all that's the main thing.
Cause I couldn't, I wasn't focused.
Yeah.
It was tough too, she was tricking us.
I know, I'm trying to throw in some curveballs.
Sorry, it's like 3 down, but it didn't roll.
You're good. It's like you're one from this
I
side.
didn't even got a notepad.
Okay, so Dallas, you can message Emily directly, she is on Zoom now, and we will go ahead and get started. So, all right, everybody remembers how to do this. Dallas, message Emily, y'all write the answers down on the cards and then just pass it over to Emily. And then we will talk about any questions where there's further questions.
And you'll just write your name on the top of it too, just so.
Hello. Right, so I'm gonna start asking the questions, so just write your answer down and pass over to Emily whenever you are ready. All right, so we've got question number 1. Emily, it's question 28 on the. It's for 1 point. Husband and wife will both be on title to the property. Wife is the only one on the loan. Who needs to be at closing to sign documents? And I'll repeat it, so for 1 point, husband and wife will both be on title to the property. Wife is the only one on the loan. Who needs to be at closing to sign documents?
By the way.
You having to work a lot today. Having to work a lot today.
I guess.
Yeah.
And then we'll keep our 4 count over there. Oh, Michelle, just going, hey, Michelle. So I'll read the answer one more time. What we're doing, if you wanna participate, is just type and send your answer to Emily only, not to the group. And then she's keeping track of everything, but I was on my first question, so I'll read it one more time for you. So for 1 point, husband and wife will both be on title to the property. Wife is the only one on the loan. Who needs to be at closing to sign documents? Was the question, so I'll let you send your answer over to Emily.
Can't wait to hear the answer, because I had this situation and I know what we did, but it may not, it's how it worked out with us.
Hey, Michelle.
Oh, I think we'll all start with that.
She's right here, I think you're just forward.
Oh,
If I can
there she is.
mention it.
It's easier to come in.
Yeah, I was gonna say, wow, like
Well,
50
that's
feet
the
away.
part she'll pass you. All right.
So you said they were both entitled?
So both are on title, wife is the only one on the loan who needs to be at closing to sign documents.
Our answers go
So
every
for
time?
Emily, yeah.
Just write your name and title.
Perfect, so since she's written her answer, do we have all answers? All right, so the answer is both of them, so both of them need to sign closing documents. And this is because they are both on the title, so that means the wife, since there's a loan, she's gonna be signing the security deed as well. Granted, she's not a borrower, nothing affects her credit or anything like that, but she does have to be there to sign documents. So anytime you have two people on title, there's a lender, they both need to be there, not just the person on the loan.
I guess I did it differently.
What, do you remember
I
what
think
yours
that
was?
Maybe they did a power of attorney.
they did
Or he signed up first.
he did everything. And then she was added
So
on
they did a deed, a trailing deed,
later, yeah.
yeah, so
So-
in that case, they would not have to be there, but they would have
So
been.
that was a trick question.
Whoever's on title always has the time.
Yep,
Because they
Unless she
weren't
was
there,
trailing deed.
yeah, she wasn't there, but she was gonna be on there, so they did the other thing.
see, and typically for us, we actually have that person who's added, they still need to be there to acknowledge that they want to be added to title. We actually have them sign something that says that they do intend to be on that title property.
Oh, she did that on, not in person,
Whatever, I mean, there's of course,
yeah,
it's not always black and white, but
yeah,
typically that's our process.
well, today.
All right, next question, for 1 point. We have Emily has signed a power of attorney in order for Amy to sign on her behalf at closing. What is Amy called in this situation? I feel weird talking about myself as there. What am I called in this situation? So Emily has signed a power of attorney in order for me to sign documents on her behalf at closing. What am I called in this situation? So I'm signing on her behalf. It's verse 29.
And right here.
Okay, one more time. Emily has a power of attorney, in order for me to sign on her behalf at closing. What am I called in this situation? Because I'm signing for her. Let me know when we have all the answers
I
then.
did this one, right? Oh, was this was this, mine, oh. This one, no,
It's wrong. I just figured I had to put something.
it's wrong,
Why the, but. I just thought you have to be there. You have to be there.
We have all the answers. I'm not right now, we're gonna.
Brian's not working that. Yeah, that's not right here in mine.
All answer. The answer is attorney in fact. So I am signing as attorney in fact. You'll hear a lot of people, you'll say, oh, I'm signing as power of attorney for you. We know what you're talking about, but technically that person signing is an attorney in fact. So when they're signing documents, it would actually be, I would sign Emily Raymond by Amy Smading as attorney in fact. So you'll see that language printed on the documents. A lot of people will say, oh yeah, I'm the power of attorney. Power of attorney is actually the document itself. But just want to get y'all familiar with those terms.
I've been there, I've seen it other times too.
Yeah.
Don't just go, yeah.
Yep, I mean, people know what you're talking about when you say I'm signing a power of attorney, but that's just, so we all know that is technically the document.
I would think there's so much longer to get time too, they just gotta do it every
Yeah.
little.
I had to write that with my long name.
Oh, yeah.
I was like,
All right, next question, it's number 31, Emily. True or false, for 1 point, a library card will work for a primary identification at closing. So true or false, a library card will work for a primary identification at closing. 1 point.
The county,
my brain and my hands. working.
it doesn't have a better birth. Yes.
All right, so the answer here is false.
The picture. I gotta get, oh no,
Yep, it's gotta have it's gonna be a government issued form of identification with a photo, and it has to be obviously not expired. So a library card would work as a secondary identification, because we just need something that has your name on it. It could be the insurance deck page, it could be a Costco card, but the primary identification must be passport, driver's license, green card, anything like that, that's gotta be government issued with a photo ID.
So I put no, meaning false.
Primary, yes,
Yeah.
the primary is
Yeah.
the trick.
Yeah, primary versus if it was secondary.
Don't go to the bank with your library card.
No, they won't allow it. All right, another question, true or false for 1 point from our 30, Emily. It's best to pay any overdue or late HOA fees as the seller the day before closing. True or false? It's best to pay any overdue or late HOA fees as the seller the day before closing. True or false? Pay those late fees or overdue fees the day before closing.
Thank you, it's my company,
Come on, too.
Yeah.
At my doorbell will ring at 8 o'clock and I'm just not even there.
Yeah. Great, so long. All right, answer is false. You do not want to pay those the day before closing. As the closing attorney, we will order the HOA letter. It's going to detail what those fees are and we will collect them and pay them at closing. A lot of times what happens if they do end up paying that the day before, say before closing, is they're gonna say, they're gonna look at the settlement statement and they're gonna say, I already paid that. We can't take them for their word, even if they're the most trustworthy person, we cannot take them for their word, we have to go by that HOA later, so that all it's gonna do is create a pain for them. Because then we're gonna collect it, they've either gotta get reimbursed by the HOA, or very unlikely that we'd be able to get an HOA letter at the closing table or an update showing that those fees were paid. So just always tell them at that point, call us to confirm, but typically you just wanna let them, have them be late overdue still, let us collect it at closing. All right, so next question is another true or false. True or false for 1 point. Closing attorney, the closing attorney that has been selected on the contract can be the holder of earnest money. True or false? The closing attorney that has been selected on the contract can be the holder of earnest money.
That has a,
Sorry, could you say that one more time?
that has a big. Okay. Right, I know, it should be considered, but okay.
So true or false, the closing attorney that has been selected on the contract can be the holder of the earnest money. True or false? That's for 1 point.
This one.
All in, okay. Answer there is true, and there definitely is an if, but it's gotta be the closing attorney selected, and there's another item on page 1 of the contract that actually shows who the holder of earnest money is. So it's gotta be listed as closing attorney, and then also they have to be listed as the holder of earnest money. So that was true. All right, next question. We're gonna do, number 11, Emily. For 1 point, and it's gonna be a 2-part question. For the first part, what is the document that will show the signing authority for an LLC? So for 1 point, what is the document that will show the signing authority for an LLC? And don't turn the questions in just yet, or sheets in just yet. Part 2 is for 2 points. If there is no blank document that y'all just put on that card, what document would the closing attorney prepare prior to closing that shows who has signing authority? So I'll read that again for 2 points. If there is no name of the document that y'all just answered, what document will the closing attorney prepare prior to closing that shows who has signing authority? So I'll read the first question again for 1 point. What is the document that will show signing authority for an LLC? That's part 1. Part 2 for 2 points. If there is no that document, what document would the closing attorney prepare prior to closing that shows who has signing authority? Let me know if y'all want me to read it one more time.
We did this last time, didn't we?
Okay, so part 1,
No, I'm saying we did this last time, didn't we?
yeah. The more we do it, the more you remember. You want me to read it again?
No, no,
That's fine.
I know it. You know, it's your job to do it. I used to tell the client, you do this and
Yeah,
that.
you can get it. I'll let y'all pass them
I got
in.
neither one right, but anyway. Here we go. It's colorful, anyway.
Dallas, are you in? Or are you playing this one?
What is this, the attorney one or LLC one still?
Yeah.
Yeah, I have no idea.
All right, so the answer for part one, what is the document that will show the signing authority for an LLC? That's the operating agreement.
You can go to the website of the Secretary of State and look it up.
So that's what a lot of people will do, so that's a great question. So Secretary of State website will show us whether an LLC is active, whether it's dissolved, whether it's inactive, so it'll give us the status. And it'll typically have the articles of organization on the Secretary of State website. That'll have, a lot of times it will have the person who has signing authority, but it doesn't give us all the documents that we need.
Gotcha.
So typically, no, the operating agreement is not on the Secretary of State website, but it'll tell us who the registered agent is and whether it's active. So we do need that information, but it's typically the operating agreement that, we'll need to.
So if you don't have it, how would you get it though?
So you'd have to get it directly from the client. And a lot of times they don't have one,
Right,
and so that's where part two comes in.
okay.
So the answer for part two, if there is no operating agreement, the document the closing attorney would prepare that shows who has signing authority is a resolution. So what would happen, let's say that it's Emily and I are the members of the LLC, and if we did not have an operating agreement, the closing attorney would draft a resolution, and it would be signed by all members or all managers, and it would designate one person to sign on, or whoever they want to sign on behalf of the LLC. The operating agreement shows who is signing authority, and if there's no operating agreement, a resolution is drafted. All right, next question.
I missed a lot.
That was a two-part one. All right, next question. How much would the transfer tax be on a $1 million property? And the second part of that question, who pays transfer tax in the transaction unless specified otherwise? So 1 point each. How much would the transfer tax be on a $1 million property? And who pays the transfer tax in the transaction unless specified otherwise? 1 point each. Transfer tax on a $1 million property, and who pays it in the transaction unless specified otherwise. So default in the contract, who is it?
This might be right. It might not be.
Wait, for 17, but I changed it. But now.
So what was the question that I missed before?
So the question
Just
before
curious.
was,
Oh, it's okay.
who is, oh no, sorry. What is the document that will show signing authority for an LLC? And that's operating agreement.
Mhm.
And then bonus part was if there's no operating agreement, what document would the closing attorney prepare to show who has signing authority? And that answer is.
Oh,
And that's the one that would have all members and all.
Emily. And my.
Oh.
That's
Pull
right.
the roof.
Yeah,
I like that yesterday. I felt so bad.
It was with my name.
Oh, really? It really was falling from somebody. That really was, oh. I felt so bad. I was trying to catch her from the back and just,
I know,
I just couldn't.
I'm glad she didn't go like, oh, yeah.
Right, that was the main thing, the fact that, yeah, we're all so happy to see it fall, yeah. Put on my jeans and all stuff, it's no big deal, I can claim that.
All right, so the answer for part one, how much would the transfer tax be on a $1 million property? It would be $1,000, $1 for every 1,000. And then the second part, who pays the transfer tax in the transaction unless specified otherwise, the buyer.
oh, I'm more.
The buyer will pay transfer tax again unless specified otherwise. All right.
Thought it was
Net-
10 cents per dollar.
A dollar,
Which
a
is
dollar
the
per
same.
I
thousand.
think it's the same, but I usually just $1 per thousand, so like 950,000 would be $950.
Is it $1,000?
It's the same, right?
I think it's, yeah.
Okay.
All right.
I did percentage wise.
Next question for 1 point. What does HELOC stand for?
Okay, thanks.
What does HELOC stand for 1 point? We good? Good. All right. Home equity line of credit. Hopefully everyone got that. 1 point, home equity line of credit. All right, next question is gonna be a 2-part question. What does FERPTA stand for? What does FERPTA stand for? FERPTA. And part 2 is gonna be what percentage withholding do you typically have on the sales price with FERPTA? What percentage of the sales price do you typically have for withholding for FERPTA? So part 1, what does FERPTA stand for? Part 2, what is the percentage withholding for the sales price with FERPTA, the typical percentage? Emily, I went rogue on this one. If you couldn't tell when I repeated it a different way.
What do you know the alcohol we had in the office yesterday? How probably.
That'll bring all the answers to the mind. All right.
Did he come back to the bottles or is it still there?
I
Just said a wild guess on part 2, but you know.
Andy came back to the wall.
Yeah.
Oh, so we,
We're storing them
so
for
we
them.
still have a
We'll keep them safe.
14 years of age stuff was good.
Yeah, that was really smooth. That
Very
was
smooth.
normally a Scotch.
Yeah.
Well, I didn't think I was normally Scotch person, it was really good. All right, we have all answers?
Yeah.
All right, so FERPTA stands for Foreign Investment in Real Property Tax Act.
Okay.
Oh.
So I knew that would probably catch everybody on.
I
like,
made the last word. Act, I knew what it was, I just couldn't tell you what it was.
Give it to her, but she had the rest of it.
Say
I
that
was
again.
saying,
So it's Foreign Investment in Real Property Tax Act.
give it to her. I mean, she had the,
I would have
It
got
sounds
it.
funny.
Instead of that.
have a point or something.
Yeah, get half a point.
See, I've had it, I had the second letter wrong anyway, so I would have never guessed that.
Ah,
I thought it was an E, I went,
And so FERPTA, the percentage is typically gonna be 15%. So that's gonna be if they're not a
yeah,
US
once I
citizen.
knew what it was, I would get, okay, yeah.
Yeah, so that's the typical percentage. There are some exceptions to it. I think the big one is if
Yeah.
the property is less than 300,000 and its buyer is gonna be their primary residence, there's some exceptions. Just at that point, you're gonna wanna talk to the closing attorney if FERPTA applies, but there are a couple exceptions, but it's typically 15%. All right,
Oh, it's not only for investors, oh, it's a foreign,
The foreign.
it's only for
yeah,
investors.
if they're not a US citizen.
Okay.
Which brings me to my next question about withholding. We've got. All right, your seller is a resident of Florida and has used the property as a rental for the last 6 years. What should you prepare your client for on the settlement statement? Seller is a resident of Florida and has used the property as a rental for the last 6 years. What should you prepare your client for on the settlement statement?
Tax.
Brian, how are you today?
This. Need that bottle.
So your seller is a resident of Florida and has used the property as a rental for the last 6 years. What should you prepare your client for on settlement statement?
Yeah, it's got to pay for not having been living in it for the last 2 years, this time for that.
What is that called? Wait, what is that called? I'm like, blank. It's,
It's not primary.
can't remember the word, but it's stayed in my room. Here. I don't know. I do know this one. Yeah.
The age hell going on.
Like, you know, I just.
Is that your fault, decision?
Yeah. I didn't have one, I have a handout.
It's,
Is it the one?
it's like,
Right?
Sí, pero creo que no tenía.
better experience word. Yeah, it's, I can't remember it. Totally found on my hand.
All right, we have enough.
Yeah.
That's lost my place. All right, it's gonna be 3% withholding.
That's exactly down.
Perfect. So yes, if they are not a
Cool.
resident of the state of Georgia, or if it was not their primary residence, they may have that 3% withholding on the settlement statement. Another alternative would be for them to calculate their capital gain, if anything.
That's what I was thinking.
And so, yeah, so we go through the checklist. First thing, are you a resident of Georgia? If you are, no withholding. Next step is gonna be, was the property your primary residence for 2 of the last 5 years? If that's a yes, no withholding. At that point, we have that whole calculation. They would wanna talk to their accountant, tax advisor, they have to know their cost basis, any, improvements or anything on the property, they can figure that all out. Well, we don't help them with that. They just tell us what the numbers are from what they've gotten from their accountant, and then we plug that on the settlement statement. So that's our checklist.
It's like totally forgot this. It's like, and I've been saying it
Some
over and
coffee in
over,
here.
and I've been talking about capital gains with somebody over and over and over, and it's just like all of a sudden was like gone.
It's a Wednesday.
Yeah.
All right, next question for 2 points, and it's a 2-part answer. If there is a lender on a transaction, the buyer may only add blank or blank to the title of the property without triggering the due on sale clause. So I'll repeat it again, for 2 points, if there is a lender on a transaction, the buyer may only add blank or blank to the title of the property, basically on a trailing deed, without triggering the due on sale clause. So who can they add to the title without triggering that due on sale clause? This is more for a trailing deed. Read it one more time. For 2 points, there's a lender on a transaction with a trailing deed. The buyer may only add blank or blank to the title without triggering the due on sale clause.
Blank or blank. Okay.
I wonder if what I scratched out was really the right answer.
Yeah, I'll go with your.
Ah.
I thought that was only,
I should have gone with my first instinct.
It was just the 2 parts.
oh, okay.
Or 1 point.
I thought that was only on a certain type of loan and not on the title.
I knew it was breaking.
Okay,
For trailing deed.
really?
There's
So-
only 2.
Like really hard, like really hard.
After the fact. And there's one.
Well, after the fact, there's, oh, I got you. Okay, I got it.
We have all answers in?
Then I got it wrong, bro.
Not out, so.
Dallas, do you answer in this one? No. All right, so in that case, we have all answers in? All right, so the answer is a spouse or an adult child.
Yeah, so I was like,
That's
yes.
what, okay, adult child.
So
That's
those
what I was
are the
thinking
answers
parent.
also.
Because I knew
So
it was
those are the
the
answers
answer child.
for if you have a loan and you need to do a trailing deed, you can only add a spouse or an adult child. So you can't add a fiance, that triggers the.
Not a parent?
not a parent, not a sibling, it's gotta be a spouse or an adult child.
Now, if you had a fiance, I guess the right thing to do there, once you're married, is to add a spouse.
Yep, you can do that, or the workaround for that would be before, so at closing, you could also get an amendment to add, or not at closing, but prior to closing, as long as it's okay with the lender, you could get an amendment to have someone added onto the contract as a non-borrower on title. As long as the lender is okay with that, that's allowed as well. But I'm talking for this, I'm talking about at closing, if they're not on anything,
Yeah.
you're doing a trailing deed, those are the only people that you can add, if there's a loan. If it's a cash closing, there's no lender involved, you could add a parent, you could have whoever you want, you could add a friend.
There's no
I
limit.
don't recommend that, but you could add whoever you want.
Right.
But if there's a loan, it's the spouse or adult child. The only other catch to that, which, I would have taken would also be, if they have a trust that they're trying to transfer to, it has to be an inter vivos trust, which means it's created during their lifetime, it's not created upon their death. And they must also be a beneficiary of the trust. So that's another catch. But with that, you're not gonna wanna tell them one way or the other, you're gonna want the attorney to look at the trust, but that is another answer that I would have taken. All right, next question, this one is hopefully a gimme. For 1 point, what is the form number of the GAR purchase and sale agreement? What is the form number for 1 point? Hope this is a gimme.
Yeah.
1 point, what is the form number, the GAR purchase and sale agreements?
Terrible at remembering those.
Yeah, tell a movie.
I'm so bad at remembering the numbers of the things.
Don't you know what it is and how to find it in school?
Yeah,
Okay, all right, so that's the F201.
yeah.
Put it 101.
101.
I get confused all the time, yeah.
I have one too.
Yeah. The
I'm telling- I
201,
admittedly said I'm terrible at remembering the numbers.
Well, you won't forget it now.
Yeah, I totally will. I absolutely will.
All right, next question. For 2 points, what type of power of attorney is needed for a seller in order to appoint an individual to sign on the seller's behalf at closing? What type of power of attorney is needed for a seller or for a buyer? In order to do anything with real estate, what type of power of attorney is needed for someone to sign on your behalf?
Okay, give me a list of all the power of attorneys.
That's nice.
Yeah.
Yeah.
And she's still gonna make between two of them, well, I think she's gonna down.
No, that's fine. Hold on. I'm running through my head the ones that I know.
What type of power of attorney? And again, what's the person who's signing called? Yep. That's not very points, but.
Right, it's like a review, what we just learned 20 minutes ago.
Make sure it's paying attention.
I gave 2 answers, so I don't know if I can get each one.
That's the Latino.
Take either one.
All right, so the answer here is a specific
Yes.
power of attorney.
Oh.
Specific power of attorney, so the other types are durable, financial, general, military. Military they'll typically take, if they have a military power of attorney in place, they'll take that.
Actually, no, good.
Yeah.
What does the durable one cover?
So durable is gonna be more of like estate planning type stuff, so it'll say, they'll have a section in there where they can initial down, they can sign for bank accounts, different stuff like that.
But it wouldn't count for that?
No, and the catch with that is that typically for the power of attorney that's an estate planning power of attorney, it doesn't meet the requirements for, like, for example, for a deed. So at that point, you need an unofficial witness and a notary, and a lot of times on these power of attorneys, they don't have that unofficial witness on there, it's just the notary that's signing, typically the attorney that they signed it with. So it doesn't meet the requirements for a deed, but also the main catch is that for a title underwriter, they want to see the power given is such a broad power on other power of attorneys. It'll typically say they have power to sign on my behalf for real estate transactions. But it doesn't specifically say they have power to sign for this particular property.
Okay,
And a lot of those documents for estate planning were also potentially signed years and years and years ago.
right.
They want that to be more recent and specific to the property.
Got it.
So that's really the catch for it, but it's also the requirement of the notary and the unofficial witness, which is a requirement for a deed in the state of Georgia. Most power attorneys don't meet that requirement of an unofficial witness and a notary. So that's kind of the catch there.
So what happens if you do have a client that went to an estate planner and they sign the document giving power of attorney to someone else to sign on their behalf, even if they're not dead, even if, you know, they're challenged or whatever, and they can't do it, then what do you do?
So we have to get approval from the underwriter, and usually their first question to me is gonna be, why can't they sign another one? What's the issue? Are they out of town? Are they at a facility and it's just not convenient for them to do so? So, and a great example was a couple months ago, I had one that was approved, it was the husband, his wife had died in a car wreck, he was in the car. And his mental state was just not, he knew what he was doing, but he didn't want to be bothered with any kind of thing, selling their home that they lived in for all those years. And it just brought him to a place where they said, we don't want to have to bring this up to him if we don't have to. He's traumatized from this event. So I explained that to the underwriter and they approved that POA. They didn't want to have to bother him with anything else related to selling their home or anything. That was approved. But it's gotta be approved by a title underwriter at that point. And if they say, oh, he's traveling, he's in the Bahamas and he just doesn't wanna be there, or he doesn't want to deal with signing another one, they're typically gonna say that's not a good enough reason. He needs to get a specific power of attorney. So it's not a hard rule, but they are really encouraging getting that specific power of attorney signed unless there's just
I think
circumstances.
So is it a good idea to get that even if you're young, just in case something like that happens?
To get the state planning power of attorney?
Or is it specific?
Yes and no. A lot of times the wording on the specific power of attorney, if you think you're gonna sell your property in the next year, I'd say go ahead and get it done, especially if you travel a lot or you've got XYZ reasons where you potentially wouldn't be in town. You could go ahead and get that done, but a lot of times it's only gonna last for a certain period of time.
Oh, okay,
So
I see.
it's not like a broad, it's, indefinite time period on that. Usually it's for a set period of time. The one that we draft, I think, is good for 90 days, I believe, for whoever to sign on behalf of the person that needs it. But yes, so there are ways to get around that, but you've gotta get specific approval and it's gotta be a really good reason, for them to continue to use an estate planning power of attorney. Any other questions on that?
It was a struggle when I had to sell my mom's house.
Right,
She was alive. But she couldn't write or talk.
Gotcha, yeah, and I've had that before too.
So you in that case?
So in that case, we got wording, from the title underwriter it was that when I was out in Florida. But we got wording from the underwriter that allowed us to have a POA executed at the table. The woman could not sign, her hand, she had
Right.
something wrong. And so we had the wording and she just put an X.
Right.
She put an X on the power of attorney.
You know what we ended up doing? A video call at the table where my mom
Just
could
nod.
nod and make a noise.
Right.
And they'll definitely make it.
That's all she was able to do.
Yeah, but they've gotta get that approval and they've gotta have there's different wording, so for that case, and I don't know the wording off the top of my head, I would just reach out to the title underwriter.
And she didn't even know she honestly, I don't even know if she understood what we were doing
Mhm.
exactly.
Just nod, mom.
But
Yeah.
we pretty much, my sister was in the background saying, Mom, yes, and she did that.
Okay.
Yeah, yeah, there's definitely, I mean, each situation is gonna have different things that we'll have to, address, but
Yeah.
for the most part, you wanna get that specific power of attorney. And just if your client says, hey, I have a power of attorney in place, go ahead and have them send it to you, but by looking at the face of that document, if you don't see specific power of attorney, it's probably gonna get a little bit of pushback from whatever attorney they propose. So just keep that in mind.
Okay.
All right, next question. Let's see, which one do I wanna ask y'all? Okay, I kind of gave this one away already, so if y'all were listening to what I said. In addition to a notary, for 1 point, who else is required to be present when a seller signs the warranty deed at closing? In addition to a notary, who else is required to be present when a seller signs the warranty deed at closing? If y'all were listening to what I was saying earlier, I definitely said this one. Dallas, are you sending it in?
You did, yeah.
Okay.
I don't remember hearing that.
You said that bottle was flowing.
Was I outside when you said that?
Just now, right?
Do we have it all? All right, answer is unofficial witness. So you
Oh.
must have a
Oh.
witness and a notary.
I think again, another official.
Oh, witness is fine, yeah,
Okay.
we'll take that.
Thanks.
I didn't do that. I wasn't listening.
So yes, on a deed, in Georgia, it's a witness and a notary that are required to be on the deed.
What does unofficial mean that at that moment? What's official and unofficial,
Those terms are, like,
right?
it doesn't really matter, witness, it's just basically a person that's not the notary, it's gotta be a second person in addition to the notary.
But doesn't it also have to be unrelated to the
Yes.
transaction?
Yes.
Yeah.
Yeah,
Like I couldn't sign
The
for Louis.
exactly.
Right.
Right.
Yeah, you couldn't be the notary or the witness for.
I should have known that. I've been witness to.
So it cannot be a beneficiary, but it can be related, huh?
No,
No?
not
It has
No
to be
related
signed
relation at all.
Yeah, not related at all.
And
I
not-
don't
okay.
recommend
Ask that question.
by in-law, I don't recommend anything. If you have any relation to that person, you do not want to witness or anything, because then it could fall into the validity of the transfer.
Gotcha.
If it was someone that was
But
related.
if friends or family or something like
If it's
that,
a friend, that's totally fine.
Okay.
It could be someone that's unrelated
To
to
be a
you,
total stranger.
neighbor,
or a total stranger. Yep,
I've signed as a witness a million times.
right?
Totally.
yep. Be anyone other than someone related. All right, next question for y'all. All right. Okay, true or false? The seller has agreed to give $3,000 in closing costs to the buyer, and that will absolutely be used at closing. The full amount will absolutely be used at closing. $3,000 closing costs, true or false?
Oh, wait a minute. Will it be used at closing?
Yeah.
Like towards something else?
So it's basically saying that it'll absolutely, in every case, if you agree to give $3,000 closing cost to your seller, that will definitely be used full amount every time, true or false.
Every time, okay.
Whatever they agree on closing costs will be used fully, no matter what. True or false.
For closing costs,
I went rogue here, I'm
for
like.
closing costs, or something else.
True or false. Seller has agreed to contribute $3,000 in closing costs, and no matter what, the full amount will be used at closing.
Hold on.
Right.
I have been doing so bad.
False.
Oh, I got on the wrong side of the 50%.
So ideally, yes, you would love to, of course, use the full amount of closing costs, but it's not always, you're not always able to use the full amount of.
Yeah, to reimburse, sorry.
Well, at that
No,
point,
reimburse, I'm sorry. Giving it as a check to the buyers, no?
Nope.
No?
nope, so at that point, if the lender, yep, so it just, at that point, if
Oh,
the
just
lender
like
will
you
only
said.
allow $2,200 on the settlement statement, you go up to the amount that the lender would allow, and the rest of it, seller quote keeps, but it's basically just, he would be able to keep $800 more than he would have had they been able to use the full amount of the closing costs. So
think
just
I would
because it's
use
on your
that.
contract for X amount of closing costs,
Yeah.
doesn't always mean that they're gonna be able to use the full amount. They'll usually try to get as much that they can, but
Right.
it's not always you're able to use the full amount.
I think I confused myself in the question.
I know, I probably worded it a little wrong.
I think I was
went
thinking,
rogue.
hey, if the seller is offering you X amount of dollars to go towards it, you could put it towards different things, like a buy down, or I was thinking the wrong thing.
Yeah, no, I was just trying to get at, just because you have that amount of closing costs, doesn't mean you can always use the full amount.
Okay, I was confused.
Well, but this might be a good chance to talk about what you can do to use up those funds, because I've been in that situation before. And we, paid multiple months of HOA dues or years of HOA dues. Sometimes
Good.
you can pay the inspection with it.
Okay.
You have to talk to the inspector, because basically
Yeah.
you'll have to reimburse your client.
Yeah, the extra
For
money you
what
could
they
use for
paid,
different
But
things.
it can be paid for there, you can.
So I can
pay
utilize it
for-
for a month.
Yeah,
And
like
that's
you get a truck, get a turn bond, get a home warranty, get like, there's a
Right.
bunch of things that you can pay that were not necessarily in the transaction, where you
Gotcha.
can use all that money.
Yeah, and
Gotcha.
basically they're, like she said, they're trying to utilize as much of it as they can. The most common one that I've seen is HOA dues. So I've seen it where typically on like the HOA letter would say, let's collect up funds for, let's say it was closing in June through the end of the year.
Mhm.
And then they would try to maybe get an additional year of
Sure.
HOA dues on there so that you can try to use up the full amount that you could of
Right.
selling credit.
Well, as she said, you could use it for a warranty or inspection or something.
Yeah, you could try to
Okay.
throw in as much stuff, and a lot of times for that, I've had the lenders kind of push back a little bit on certain
Right.
items.
Okay,
But they have to allow it. At that point, the lender will work with you to say, yep, okay, this is, we'll add this on there, that'll contribute to it. Yeah, home warranty, termite bond, HOA is what I've seen is the most common that they try to get more of. But yeah, you try to get as close as you can, but you can't always use the full amount.
Dom Perignon, champagne and closing. No.
Would that be good?
Right.
Down payment, furniture.
All right, next question, and this is going to be a three-part question. So we have, here we go, so the first question, property is owned by Amy and Emily as joint tenants with rights of survivorship. Property is owned by Amy and Emily as joint tenants with rights of survivorship. I have died. Who owns the property? Is question one. So property is owned by Amy and Emily as joint tenants with rights of survivorship. I, Amy, has died. Who owns the property? That's part one. Part two. What do you need to proceed to closing? The property is owned by me and Emily as joint tenants with right of survivorship. I died. Who owns it? Part one. Part two. What do you need to proceed to closing? And part three. What else will title need in addition to part two? At closing, and the hint for that one is you sign it at closing. So what is that document? In addition to document number two, what's document three that you would sign at closing? I'll repeat that, I know it's kind of tricky. Property is owned by Amy and Emily as joint tenants with right of survivorship. Amy, I have died. Who owns the property is part one. Part two, what do you need to proceed to closing? And then part three, in addition to the document that you need, which is the answer part two, what else will the title or the closing attorney need in addition to that document, which is the answer number two? And the hint is like sign it at closing, number three. Does that make sense?
Yeah,
Okay.
yeah, sure.
I'm like, I have no clue.
And do you want me to try to word it a different way or?
No, it's okay, I'm just, I remember the last one.
But it's cool because you're learning all this stuff.
Well, I've done this before, that's why I'm like, I have no clue, like,
Okay,
I can't remember the last
just
part.
let them figure it out, right?
So yeah, part two is what do you need to proceed to closing when I've died? And then part three is in addition to the document that you need to proceed to closing, what else will you have at closing? And it's something that you sign.
I don't think this is right. I don't think it's right. Here's these two, I've got to finish mine, I'm not understanding. So maybe. I might get one.
Are we looking on?
Yeah.
Yeah, let's do it part. Feel that. Do you answer part 3 on that one? Nope, okay. All right, we have all the other answers. All right, so here are the answers. So property is owned by me and Emily as joint tenants with rights for survivorship. I have died. Part A answer is Emily owns the property, because once I die as joint tenant, it reverts fully to her without going through probate. Part 2, what do you need to proceed to closing? You need my death certificate. So that's part 2. Part 3, what else would title or the closing attorney need? It's a document that they'll sign at closing in addition to my death certificate. Emily would sign a joint tenant affidavit at closing, and that would be recorded to show she owns the property with me as joint tenants. In addition to the death certificate, that affidavit would be recorded. So anytime it's joint tenancy, there will be a joint tenant affidavit that's signed at closing, so they don't need to do anything prior to closing. Sometimes people will want it recorded prior, you don't have to do that. The stuff that you have to do prior, of course, is probate. That's where there typically would be an executor's deed signing the 50% out of that estate over to the person who would sell it. But for joint tenancy, death certificate and a joint tenant affidavit is what you'll need.
Okay,
All right, Emily, what's our scoreboard looking like?
so bad, I don't
A
know.
couple more questions.
How am I
We're
still
close.
a It's like, how am I still a realtor right now? That's why you're here, so we don't have to
Right,
remember all this. That's you, you have
That is
to.
the good part. I'll tell you all this stuff in the transaction, but.
We got Michelle in first place.
Right.
Yeah.
Right now, I've been close behind. Denai close behind, everyone kind of close behind.
Okay. All right.
Just do a 10-pointer.
We're gonna do another 2-pointer though. All right, so this is back to those closing costs. So, for seller paid closing costs, this is gonna be 2-point answer here. What is the VA cap percentage for seller paid closing costs? And part 2 is what is the FHA cap percentage for seller paid closing costs? So part 1, what's VA cap percentage? Part 2, what's FHA cap percentage?
Wow.
And a bonus question on here, so this is actually a 3-pointer. Bonus, what is the cap for conventional? And a hint is that one is a trick question.
I was gonna say, can we write all that down like it times? Never gonna be it.
Question 1 for seller paid closing costs, what's the VA cap percentage? Question 2, what's the FHA cap percentage? And bonus, what is the cap for conventional? And my hint on that is that that's a trick question. Getting you an answer.
I haven't ever done it yet. So I haven't done it yet.
I used to do a lot when I was in Destin with the airport, the Eglin right there, we did a lot of the Eglin. And that's for those like military POAs, we had so many of them. And those were typically get approved immediately. I had the military, at that point, they're probably already either deployed or overseas or, you know. We have all answers. All right, answer 1, for VA cap percentage, it's 4%. FHA cap percentage is 6%. And the trick question for conventional is it depends. The answer is, it. No, you're right, you said that, I was like, oh, there's the answer, but it's hard.
So 4,
It depends on the amount of the down payment for.
tell me again, I'm sorry, the VA is what?
So VA is 4%, FHA is 6%, conventional, it depends on the amount of the down payment. So at that point, you want to chat with the lender, see what that cap amount is, but 4% VA, 6% FHA, and it depends for conventional.
And this is the maximum,
Yeah, that's the cap percentage for the seller paid closing costs, and that kind of goes back to, you may not be able to utilize the full amount of the closing cost that's on the contract. So it depends on what type of loan, all that good stuff. All right, guys, I think we have time for maybe one more question. Let me find a good one. All right. Point here. That's a two-part question. Part one, your seller is wanting to sell one of their investment properties and defer taxes and capital gains on the property. Who would you recommend that they contact?
You.
The answer is always always. So that's, I know, I should give credit for that.
They're accountants.
Part one, your seller is wanting to sell one of their investment properties and defer taxes and capital gains on the property. Who would you recommend that they contact?
That's it? Is it important? Just one
So
part?
that's one part. Part two. And I'm gonna try to not give away part one here. What is the title of the entity who facilitates part one? So what is the title of that person who facilitates part one?
Oh. Oh.
I don't know how to spell
Okay, so
it.
that's making me think my part one is wrong.
I have like, so
Right.
it's a person at the. This is hard without.
Right, I
spelling
gotcha.
it for part one. So it's the title of the person from the answer to part one, it's the person that would technically be facilitating that part one answer.
Oh, geez.
Once I say it, but I don't get
No, I don't know.
So again, part one, your seller is wanting to sell one of their investment properties, divert taxes and capital gains. Who would you recommend they contact? Part one. Part two, what is the title of the entity, the person who facilitates part one? So, exactly.
Um,
Yeah, all right, so seller wants to sell investment property, divert taxes, capital gains on the property. You should recommend they contact the 1031 exchange company. So there's plenty of them around. You need
I
that,
should have known that answer.
let us know, but yeah, 1031 exchange. And then the bonus, what is the title of the entity who facilitates the exchange? The qualified intermediary. So that's
Should've known that
why
too.
we're at the 1031.
It's like, I should have remembered that.
Thank you,
but I
I'm like,
forgot.
oh,
Would you put it?
I wasn't.
I did put qualified.
That's fine.
I should have known that.
Just-
I've done one commercial transaction that's been
It
wrong.
is 1031.
Zero.
And I totally forgot what all that was.
And so another question that I won't ask y'all because we are out of time, so Emily, I'll let you tally up the points. Is for a 1031, make sure that if your seller is going to utilize the 1031, they already have a person in mind. They cannot, I've had this come up at closing, they've thought about it a couple days prior to closing. They cannot receive the proceeds. The minute that the proceeds hit their account, that is a taxable event. So it has to be set up in place, proceeds have to go to the 1031 exchange. There's also the timelines on finding a property to have the funds go to. So there's all kinds of different timelines, I can do a whole class on 1031 exchanges at some point. But basically, just remember that needs to be in place way prior to closing, they need to be working with that person so that they can have that set up and let go. Because they cannot receive those proceeds.
All coming back to you.
All coming back. So what's our point totals here?
Amy, can I share something that I just learned about 1031? So we have some investment properties and the school system of the city where we have them is buying the entire subdivision and all the properties surrounding to expand. So we were really concerned about our timeline, because we bought those properties back in 2011. The appreciation has been insane, and we've never had a mortgage on them, and so Louis was doing some research and found a product that's called a 1033 exchange. So it's kind of this, it's in the same tax, yes,
Yeah.
it's also a tax deferral. The difference is with the 1031, the money goes to the intermediary, and then you have the 180 days, right, to complete the purchase.
Yep.
Of the next property that you're buying. With a 1033, you can only be used when you're forced to sell the property. So like in our case, they're forcing us to sell the property, or it's gonna go with eminent domain. Either we come to an agreement, or it's gonna be eminent domain. But with the 1033, the money goes to you as the owner. Does not go to the intermediary, and you have 3 years to complete the purchase. Whatever you're gonna be doing, so I just.
Yeah.
Thanks, Louise, because he's the one that found about that, but it's a good, eminent domain and forcing somebody to sell is not something that we come up, with every day. But at least it is an option out there that you can use your money however you want to throughout that time, and you don't have that specific quick timeline.
That's great to know. Yeah, won't come up all the time.
Yeah.
That's great to know.
Yeah.
Awesome. All right, what's our totals? Who's our winner?
Just want to show.
Second place, Ivan with
Oh,
and then Michelle at first with 25 points. Yeah.
There
you go.
And then hopefully you'll learn some fun facts in here, and I will continue to come up with some more trick questions for the next group.
Yes.
Until then, Michelle has the
crown. I have
crown.
Nice.
And the pen, it's a really nice pen.
Congratulations.
Thanks, guys. Thanks, Emily and Amy.
Question, you were talking about, like how you can change title and that due on sale. So I'm taking my dad's property. He has a mortgage on it.
Okay.
And so the mortgage company said, just that I could add my name onto the title, and then they would transfer the property over to me.
Okay.
But when I called, the closing attorney to change the title, and the bank as well, I said, would I put my husband's name on it now or later? They said, go ahead and put your husband's name on it now. But it sounds like you're saying, to put my husband's name on it now, it's gonna trigger 2 months too.
So you basically the deed would be from your dad to you and your dad. So it'd be from him to both of you.
And I asked that question, they said, no, go ahead and put your husband on now, don't wait, because I will eventually take my dad off and I'll be the only person on there with my husband.
At this point, technically, it would trigger dual and sale.
That's my
To
thought.
have your husband at it, because he's not your dad's adult child.
Right, and then I asked the lender, and they said, no, you're fine, as long as you're on there, he can transfer it to you. I was like, are you sure? So now you're making me feel like I was right.
Technically, that would trigger it. Here, in all practicality, are they gonna do anything? Are they gonna call that loan due and, due and payable? No, probably not. As long as you're making the payments, in all reality, they're not gonna do it, most likely. But I can't recommend that you do it because technically it would trigger that.
Right.
So, yeah, the correct way to do that at this point, which I'm not saying to do this right now, but would be to do a refi and get your husband added on there. That would be the correct way to do it.
Okay.
But I'm not telling you to do that with interest rates right now. That's totally up to you, but yeah, technically, it would violate the dual sale.
Right. Yeah, because they're letting me just take over at his.
Yeah. That's totally up to you at that point, but again, in all reality, make those payments, they're not gonna touch the loan. But I also can't recommend it. So that's the catch.
Well, I want to make sure I don't recommend that to somebody else either. So.
Yeah, it's adult child or spouse or that trust, but it's gotta be inter vivos, which means created during your lifetime. And the person also has to be a beneficiary under the trust. So that's the other catch for that. And the difference between that, and you all probably know this too, is for the trusts are a whole different beast. They're great. They have a lot of benefits to them. But with a trust, when I say inter vivos, that's created during their lifetime, there's times that people have estate planning documents in place that upon their death, it would transfer into a trust. So basically their property would go into a trust. It's created under their will typically. So it must be a trust already in existence. And that's not, if you have stuff in the trust, call the attorney. We'll look at it and walk you through it. But that's the kind of catch there. But yeah, technically it would violate.
Yeah, I thought.
Yep, you're correct. All
I
right.
think, now thinking about it, you guys as coaching attorney are probably the only ones that touch a little different things that pertain to other specialties within law, such as estate law, which is different from what you do. Oh my gosh, yeah.
So fun fact, I actually did estate planning before I started at McMichael grade. So I was there for a year and a half, so I know enough to talk about it. But I also will always refer out.
Sure.
I won't touch it anymore, but I at least
Right.
know the
Cause you're not
document.
keeping up perhaps with it as much and, yeah.
Yeah, and especially every, stuff changes so much, especially with like state tax and everything. I don't wanna touch that with a 10-foot pole
Yeah.
anymore because I haven't done it for 7 years. So I know enough to where I can tell you, but enough to where I also don't know.
Yeah.
All right, well, thank you for coming in. Any other questions?
Thank you for doing this.
And I got 2 extra jars of gravy in the refrigerator over there. Ivan has claimed one. If anybody needs a full mason jar of gravy.
Oh, thank you.
I don't.
I don't, but
Bring
thank
it back.
I don't either. I'm gonna toss it. I don't need all that.
you.
I don't say that, that's great.
I know,
I
only,
don't know.
Yeah.
Will it keep?
Yes, sir, that's it.
You think so?
so,
Oh.
It's been in the refrigerator.
Sure.
yeah,
Yeah.
take it home.
All right, I was like,
Yes. Cool.
Thanks again, guys.
Yes, and if y'all have any topics you want me to touch on and more
Thank
depth
you.
or whatever, let me know too. I can do a class on any kind of topic y'all want me to do. Otherwise, I'm just gonna keep on quizzing you.
thank you.
Thanks, guys. All right, thank you.
Thanks, Alice.
See ya.
Oh, here's your 3.5s.
Is there a topic y'all want me to go in more depth on or just keep?
I think what you're doing is pretty